will start off by saying thank you for being here this evening. My name is David Manning. I am the chair of the Public Health and Safety Committee. I live right on Hackman. Y'all drive by my place all the time. Wanted to go through a little bit of the format for this evening to help everyone out and understanding the what and the why. You just were bored for 3 minutes because of the what. Now I'm going to tell you the why. This is a public health and safety meeting. We have to follow a certain order of business. We are going to hear today from Jordan Garrison. He's our state's attorney for Macoupin County. He will be going over different aspects of the legal lens that we need to look through things. Look at things through, and some of those challenges that we have here locally, especially. This meeting is being recorded. It will be, hopefully, as you see me struggle with the technology, hopefully it will be available tomorrow on Facebook. We'll have a link on Facebook for the YouTube entry of this meeting. Hopefully everyone's had a chance to sign in. We do have a few things I want to point out as far as the way the meeting will go. We'll hear from Mr. Garrison. We'll also hear from Mayor Newhouse, Chief. At the end of that, we hope to have time for public comment. That public comment, a few things I want to make just clear. As far as the way meetings are handled, and if you've ever seen meetings on YouTube, I'm sure you have, we'll have a mic in which you can come to. You will state at your name and your comment or question at that microphone. We ask that you keep those down 60 seconds, 90 seconds on that. Those questions, comments are directed to me, the chair. Everything goes through the chair at these meetings. The chair then can delegate to someone to answer, or we can move on to the next, say, duly noted, your comments duly noted. That's the way the process goes. We're not allowed to address anyone other than the chair, so don't turn to your neighbor and start pointing at him during the meeting while speaking. It's not the way it goes. You'll be out of order, and we want to make this as productive as humanly possible. So the other aspect of when you're called to speak, it must be on topic. Our topic tonight, obviously, is the new laws that we are under here in Illinois, and moving forward with policing and bettering our community. So that is the scope of the questions that we can have for this evening. Anything else, if you ask why a certain street sign is painted purple, that's not for tonight. Tonight is public health and safety meeting. The other aspect I wanted to put out here real early is that we have a council meeting tonight at 7. So there's a hard stop on this meeting at 6:45 because we have to get down to City Hall and take those seats. This meeting cannot continue because I have to be in that one, and I also have to chair this meeting. So those are the aspects that everyone needs to have in mind as we approach this. Was I going to go to you next?
You know what? I'll wait till we'll go to Jared.
Okay. For the sake of time, I was trying to drag my feet a little bit so we can get a few more people in here. But I'm going to turn it over to Jordan Garrison. He's our state attorney. He has a presentation in PowerPoint. He might end up inheriting my microphone. If his isn't hot enough, we will find out. Thanks, Garrison.
Thank you very much, Chief, for inviting me. Thank you all for coming tonight. I am Jordan Garrison. I'm the Macoupin County State Attorney. Can everybody back hear me as I speak? Good. Thank you. We're okay. I have been prosecuting since 2009 when I prosecuted my first case. I became a full-time assistant in 2010. I was elected as the state's attorney December 1st of 2020 in the middle of the pandemic. We started to ease restrictions in early 2022 and really got into full swing with prosecution in August of 2022. So I will go over some statistics of my office, and then I'll move on to the Safety Act. So the structure of my office, I need my son if that's possible. I'll tell you what it says. The structure of my office, we have 2 prosecutors, including myself, one person for 44,000 people in Macoupin County. I have 2 support staff. One is retiring on October 1st. So it'll be down to one support staff at the end of the month. Hopefully we'll hire somebody. Since COVID restrictions were lifted in August of 2022 through August of 2024, that would work out to be a 25-month window. Our rolling 12-month average of filed cases in Macomb County works out to 290 felonies, 217 misdemeanors, 58 misdemeanor domestic violence, 113 misdemeanor DUI offenses, 584 misdemeanor major traffic offenses, 2,257 standard or minor traffic offenses, 143 that should be juvenile abuse or neglect cases, and 34 juvenile criminal cases. In addition to criminal prosecution, my office handles civil work for the county, and we also do mental health cases for the county. With our caseload, we must open at least 5 misdemeanors or felonies per day and close 5 misdemeanors or felonies per day, no matter what we're doing, jury trial, mistrial, or otherwise. We have 2,000 traffic citations and entire juvenile docket and civil docket that are not part of those 5 cases that also must be addressed. So what has happened over that time period? Over that 25-month window, we have 219 cases in the Illinois Department of Corrections or Illinois Department of Human Services. That would be your mentally unfit individuals not guilty by reason of insanity for long-term incarceration, including 3 murder trials, 1 5 murders in total incarcerated, including the longest sentence since the 1980s. The first jury trial went for murder since Pretrial in 1988, and the second jury trial as well. We've also put 12 Class 1 Class X meth dealers into prison at an average of 12.95 years. Class 1 would be they're delivering more than 5 grams, so not personal use. 5 long-term incarcerated sex offenders, including 2 trial wins for sexual assault, with 1 of them receiving 5 years below the maximum sentence. After we go through just those cases in 25 months, we put another 197 cases in prison for more than 1,000 years of incarcerated time during this window. And when I say that, you're going to say, you're lying to me because I know what's happening on the streets, and I see what's happening on the streets, and I understand that. So that's part of what we're here for tonight, is to explain the disconnect from violent crime and high-level prosecution and to what we're seeing in our communities, because the Safety Act hamstrings law enforcement and to extend my office. We will start the Public Fairness Act, so PFA. We'll call it safety here. We'll go through the PFA, we'll talk about different points, and I'll try to explain why I'm here objecting to getting long sentences on violent crime, but we're seeing more vagrancy in our communities. We will go through some of these elements. This presentation is what I gave to law enforcement and other stakeholders. It's a combination of what I reviewed and what you see at the bottom, the Illinois Implementation Task Force. It is part of the Supreme Court's wing for implementing this act, so it's a lot of that presentation from them. We'll go over the elimination of cash bond, the requirement that pretrial people must be released for most misdemeanors and non-violent felonies, limits the eligibility even for ones that can't be detained unless there's a safety or flight risk, encourages summonses before warrants, that's for failure to appear, we'll get into that, outlines the use of electronic monitoring and why, although it sounds good, is actually bad, and then the risk assessment tool, and we are not going to go over the final part. That was for people that were incarcerated when the law took effect in 2023. This is the new process that people must follow when it comes to arresting individuals and going through the court system. I will make this slideshow available to the committee. They will email it to anybody that wants it, or I will email this out to everyone that wants it. So we're going to do stop by law enforcement, custodial arrest, and detention. That's the 3 categories that we're going to call this. That is not, people that wrote this bill did no prosecution. So those are not terms of ours. When you are stopped by law enforcement, you are detained. They don't want us to use that language anymore. They want to use it on the back. So we're going to use stop by law enforcement, booked and charged, detained as different decision points. And so stop by law enforcement, it is presumed on all offenses they shall be released from the scene. There are ways around that. Once you meet that other factor, it moves on to the next step. Arrest, charged, and booked at the county jail. Once they are arrested, charged, and booked at the county jail, it is again presumed that they shall be released from incarceration under the law at the county jail. So your chief or his agency takes them to Macoupin County, they're booked in and fingerprinted, they get out of jail right away. If they need to be next certain, then we go to first appearance. They can be released with conditions if it is a non-detainable felony, and yes, there are non-detainable offenses. Or if it is a detained, will file a petition to detain. There is a detention hearing that happens at that point in time. At the detention hearing, the judge can issue conditions of release, just like every step of the way, or detaining if the judge finds by clear and convincing evidence that the person is a threat to the society or a willful risk to flight. Clear and convincing evidence is the second highest standard, right below beyond reasonable doubt. We are doing that a lot in Macoupin County. I'm going to walk away from the slide for a second. Hopefully it still works. This is from the Administrative Office of the Courts. Detention petitions have been granted 63% of the time in the state of Illinois. They've been denied 36% of the time. So you have a little under a 2/3 success rate statewide. If I get this to work, now. In our county, we have a 95% success rate in detaining individuals. We are beating the state average by 20-something points. Since the implementation of the Safety Act in mid-September, 119 people have been incarcerated under the Safety Act in Macoupin County. We are beating the state average by a wide margin. Moving on to the next slide. Again, we're not going to go all through these, but these are the pretrial decision points that we have to go through. Release from citation, release from custody, pretrial first appearance, initial hearing, out-of-county warrants or a special issue, the detention hearing, and modification. That are the decision points we'll have to make on pretrial. We're going to skip past that because that's for law enforcement. Here's what everybody wants to know about. This is probably the most important slide, so pay attention here. Law enforcement must issue a citation in place of custodial arrest to those charged with all Class B or C misdemeanors. Those are what we call our non-detainable offenses. You cannot take someone to the Macoupin County Jail for those offenses except in very limited circumstances. We'll go. So what is a Class B and or C misdemeanor? Trespass to real property. If someone comes onto your land, you saw this in the news media, and they cause a scene, they can remove them from the land. They cannot take them to the Macoupin County Jail for that. Disorderly conduct, yelling, screaming, threatening, acting a fool in public for the lawless insurgency. They can cite them. They cannot take them to the Macoupin County Jail for them. I apologize. Speaker. Now, you don't have to take the word for it. When you get the slide and the question, that's the statutory authority that's on there. And if you don't need the statutory authority, that's the House bill and page that you find out as well. That says that. There are three exemptions from the 1, 3, and 2. Number one, the officer believes the accused poses a threat to a person or the community. This cannot be because they committed to Class B or C. It has to be something beyond that, right? It's very convincing. In that scenario, officers could take them to the Macoupin County Jail, but they will be released tomorrow as it is a non-detainable offense. The accused has obvious medical or mental health issues under point 3. Everyone's doing that. If they're actively bleeding, injured, or if they are in a psychosis state, they're taken to the hospital. Part 2 is the workaround that's most commonly used by law enforcement in Macoupin County. Arrest is necessary due to persistent criminal activity after a citation is issued. So I go on to Spooch's property, I yell at him, I scream at him, I'm not going to leave. They come out, they cite me. They say, you're trespassing and disorderly, leave now. I throw the citation to the ground. I can be arrested at that point in time for persistent criminal activity, but law enforcement has to go through those steps. I am taken to the jail. That is a non-detainable offense, and I'm released the next day. This subsection down here also shows that law enforcement has the discretion to release for Class A's and felonies beyond the normal Class B's and C's. Again, I'll give this out in email. This is the pretrial decision points that law enforcement now have to go through just to take somebody to jail, and and the modifications. We talked about this, and I'm trying to move quickly because I know there's a lot to cover here. As I said earlier, that's the statute there. Following arrest and booking, there's a presumption, even before they see the judge, that they shall be released from incarceration on all offenses. If they're charged with an offense for eligible for detention, the person can be held for initial appearance in front of the judge. We'll get to what is a detainable offense briefly in a few moments, but they must be released unless you have something more. If you look at our probable cause sheet law enforcement fills out, there's a section that gives probable cause for, let's say, burglary, which is a non-detainable offense, and then they have to describe the extra reasons that we are putting in the jail overnight. This is actually a good thing that the safety act allows defendants to communicate with lawyers and family members. If I was being arrested, I would hope that I would have that right. The justice stands their rights there. We're not going to go with that. This is once you get through that first checkpoint we did earlier. This is released from custody and all decisions that law enforcement must make before the person can be held for 48 hours for initial appearance. So this is pre-first appearance activities. So those arrested for an eligible detention eligible offense must appear within a judge within 48 hours. So what's that mean? Friday, our day ends at 4:30. We don't go back late 30. That means we do bond court most Saturdays, or all Saturdays. And we also do bond court most Sundays as well as required. So if you see someone taken to jail on a Friday night by non-detainable, since court is at 9:30 on Saturday, they will be released the next day if they're not detention eligible. The defense counsel must be appointed prior to the hearing and give an opportunity to confer with the clients and have meaningful contact. We have standing order. The public defender's office is automatically appointed to all criminal defendants that are arrested in our jail. That means, yes, they're coming in on Saturdays as well to work for bond court. They must be present in person. There's actually a Supreme Court stay that right now. We're doing all of our first appearances are done amongst the closer television sets, so that order runs out. They must conduct a pretrial risk assessment. So what ends up happening is that the Supreme Court has an employee at the Sheriff's Department or a detective from over in Litchfield, great guy, goes through the evaluation and scores them from 0 to 14. This is to inform the judge of the risk that they are in the community and determine whether they should be released. This metric is highly broken, but is considered by the courts. The reason it's broken is, let's say, methamphetamine is a non-detainable offense. What we're seeing now is that the methamphetamine offenders are scoring the high scores 8 and up. What we're seeing on sex offenders who don't have history of drug addiction, typically don't have previous coming out, they're holding jobs, are scoring 0s or 1s. So when we go into our hearing, we're already hamstrung with this type of evaluation. That being said, Judge Meyer has been pretty amazing about holding sex offenders in custody. And then protecting the victims. Every law enforcement agency, if you are a victim of a crime under the Victim Rights Act, is required to give you a form delineating when our hearings will happen. And if you come to court for that, I will talk to you about the court protection process. And this is that process. You can get that in the email. Setting conditions of release. So there's a presumption of personal cognizance. That's the statute. Presumption they must be released unless petition to the date file. Right there. Prosecution must prove by clear and convincing evidence. That's the statute. Additional conditions must be necessary, least restrictive, and individualized. That means if we're releasing, we're into that, we believe that you need to have drug treatment. I have to prove by clear and convincing evidence why you need drug treatment in the courtroom. Conditions cannot be punitive, shall not mandate rehabilitative services. That means I can't order someone to go into inpatient treatment. I can request they be evaluated, but I can no longer order them to go into inpatient treatment or actually get drug treatment. Electronic monitoring is restricted to limited circumstances. Again, we'll get to that. And most factors to consider, there's more factors under violation of protective orders. We'll get to that. This is the flow chart for setting conditions of release. I'm trying to think if there's anything important on here. We'll talk about GPS monitoring now. In limited scenarios, you can put GPS monitoring on. Some counties swear by it, and it's my opinion that we do not do GPS monitoring for one reason. If you are placed on home confinement with an ankle monitor, every day that you're on pretrial release with that ankle monitor, that's considered by the state 1 day you serve in the Illinois Department of Corrections. So if you sit in your home with an ankle monitor for a year, you just developed a year of time served in the Department of Corrections. So a 2-year sentence by the judge means you get let out because day-to-day credit. So we try to avoid electronic monitoring as much as possible. Orders imposing conditions of pretrial release can be appealed at all times. So we have the conditions of release that are set by the judge. The judge orders that this person must get an evaluation for drug treatment. They don't like that. They can appeal that. They get a free lawyer, and they can fight that the appellate level. This is the new right for defense. All orders revoking or denying pretrial revocation can also be appealed. We've seen more appeals since September of last year than I saw in the first 13 years of prosecution. They keep appealing these bond orders and trying to figure ways around it. On a good note, none of the appeals have resulted in anyone being released from the county. So here's the meat bones. Detention hearing. If the person commits a detainable offense, we're going to get to those. I have to file a petition. I have to allege the person is a real and present threat to the safety of a specified person or the community based on specific articulable facts of the case. What that means is this person committed residential burglary. Residential burglary is a detainable offense. Just because it's a detainable offense doesn't mean you automatically get to stay incarcerated. We have to prove not just they committed the crime, but there's extra factors on top of the fact that they committed this crime that requires them to stay in jail. So we can't just say Resburg keep. We have to say Resburg keep for these additional reasons that we must prove by clear and convincing evidence. The statute's right there. Those subsections down below, again, if you get the slideshow, are all the detainable offenses that applies to. Attempt also applies to that. So attempted murder, attempted home invasion, things like that will also be detainable if we prove those facts. Willful flight. It's one of those things that the legislature put in there. Like, you can prove willful flight, you can detain them on a class 3 and above. You cannot use the fact that they failed to appear in court as willful flight. You have to prove that they're trying to hide from the actual prosecution. So the fact that they don't show up for court doesn't count towards willful flight. We have to prove by clear and convincing evidence that the reason they need to be kept is that they're going to run to Mexico or they're going to run to Florida or something along those lines, which is a very high burden, and I don't think I've ever run across this one time. Also, this is the other fun thing. It's only eligible on willful flight for class 3 and above felonies. So Chief Doe arrests somebody on a fentanyl case. He has less than 1 gram of fentanyl. That is a class 4 felony in the state of Illinois. He looks at Chief and goes, I've never been in trouble before. I'm going to Mexico tomorrow. See ya. Chief has to release him right there. He can't keep him. It is a class 4 felony, not a class 3 felony. There is nothing that you can do. So let's go through what offenses are detention eligible. You can be detained for any non-probationable felony. You'll see later on your non-probationable felonies are mostly laid out. This is basically used under 2 scenarios in Coogan County. One of those being felon possession of a weapon. That's a non-probationable. It's not listed anywhere else. They can be detained. The other offense is habitual criminal. Habitual criminal also was changed under this act. I don't have that slide up here. But it went from 2 class 2s, so 2 burglaries after the age of 18, to 2 class 1s, to higher, that are not theft crimes, to be eligible to use any under that. So they make it harder for that offense. I jumped ahead because I thought this was a fun one. Under the Controlled Substance Act, I was to take 2 grams of methamphetamine and go to Staunton High School's parking lot, and I was to deliver it to this individual here. And Chief arrested me right there. Unless Chief can prove that I'm a danger to the community and that I pose a serious risk not to appear in court, he can't detain me. Judge can't detain me. I can't do anything. I've been prosecuted for almost 15 years now. I've never missed a court appearance. You can't prove that. That is a problem. But that is the law. There is the statute. You can look it up when you get the slideshow. The defendant is charged with a forcible felony, which used in this section. This is what's even great. In the Pretrial Fairness Act, they created a special section of forcible felonies. something that's even smaller than the standard definition of forcible felony in the state of Illinois. It goes out for the heavy hitters: treason, first-degree murder, second-degree murder, predatory criminal sexual assault of a child. I'm not going to read all of those things, but we need to go over 3 points here. It says down the bottom, any other felony which involves a threat or infliction of great bodily harm, permanent disfigurement, or disability. When we deal with that, we talk about aggravated fleeing, including from cops. There's a risk you could run into somebody in harm. Your assault charges, those qualify there. What doesn't count is aggravated battery. This statute says right above that, aggravated battery resulting in great bodily harm or permanent disfigurement. And the law, the expression of the one is at the exclusion of the other. The courts have ruled that only aggravated battery causing great bodily harm is a detainable offense. So right now, I can walk over to Chief, I can punch him in the face, I can not break any bones, he can take me to jail overnight, but I can't keep him. I can't be kept. I get out the next day. That is the law we are subject to right now. Also, with burglary. So, burglary is entering into a building not residence to commit a theft and or new felony offense. If I were to go into someone's shed and property, steal a souped up $10,000 zero-turn lawnmower, and Chief catches me red-handed, he can take me to jail. I cannot be taken. I must be let out the next day. That's the standard. Unless the victim is there and threat forces, or there's force used against that person. Typically, what we call force used against a person in theft is a robbery, not burglary. They basically try to create robbery as the only thing there. So we cannot keep someone in for burglary. We're seeing this pretty frequently. Rural Cooper County, stealing from barns, stealing from sheds, things like that. You cannot keep that person in jail initially. This is a unique one, stalking. So, with the stalking charge, speaker doesn't like move over here. The stalking charge, I have to prove to be able to detain the individual that they're going to carry out the threat of the stalk. So, if I call somebody around in the community over and over again, hide and peer at them, jeer at them, but I never threaten them, I may be stalking them, but I'm not eligible to be detained under the act. Even the legislature sees that as ridiculous, and they're talking about changing it in future versions, but that's the current version of stalking right now. Unless you're carrying out a threat, we cannot detain you. Violation of order of protection, now not stalking, but violation of the stalking no contact order, and civil no contact, that is basically your sexual assault orders. Those can be detained. They still have clear and convincing standards. So my wife is order of protection against me. I call my wife the next day after I've been served with the order of protection. I beg her, please, I'm sorry, forgive me, drop the order of protection. I've committed an order of protection violation under the statute, but I've not created a standard where I'm a danger to that individual based off of that unique action unless there's something else. So even if I were to file a petition to obtain that, I would not be able to be held under the current state of law. This just says that your sex offenses are eligible to be detained except for the ones that I've listed: prostitution, obscenity, public indecency, adultery, fornication, bigamy. Yes, adultery is a felony in the state of Illinois. No, I will not charge it. I have too much going on to deal with that. But recently our judges have been very good about holding sex offenses in our jail. Then they write various other charges that they felt were to be detention eligible, and they're all listed through here. You see residential burglary. I don't know why I mentioned that. That's already non-probationable. Firearm trafficking, military servitude, some stuff never charged. But all these offenses are also determined to be eligible for detention. Felony violations for cruelty to animals can be held, and certain violations of DUI can be held. So the procedure is the state's attorney must file a petition to detain during the detention process. That slide that we showed earlier showed I filed says 125 in the last 12 months. That detention hearing must be held in 24 to 48 hours. That a thorough hearing process is done. Each party has the right to appeal a decision, and even after the judge detains that individual, at every pretrial conference, every jury trial, bench trial, every hearing from the start of the detention, the judge must revisit that, and we must have a hearing on whether or not the individual still should be held. So let's take the scenario: individual has a drug addiction issue, and they broke into your home to steal from the house. They have no criminal history. Under this scenario, the judge detains them. He believes they're a threat to the community. Pretrial services, the public defender get an inpatient facility for drug treatment. We have to do the least restrictive method. We also have to show by clear and convincing evidence that no conditions can fix this. He or she has never had drug treatment. This individual will most likely be required to be released to drug treatment. They will have to come back to jail afterwards, but they will most likely be required under that scenario. This is the draft of the detention hearing process that's being done. The only thing that's unique on this is back in the old system, we would charge somebody, we'd have what's called a preliminary hearing. After the preliminary hearing, I would have to give all the documentation that I relied on for that case to the defense counsel. I must now do that prior to the initial hearing. So we solve a cold case murder, and we have 10,000 pages worth of documents, and we arrest an individual. Within 24 hours, I must deliver that 10,000 pages to the defense counsel before the next hearing. It's just another burden to make it harder on prosecutors. This is one of the few things we have a choice on, and I think we made the right choice. If someone fails to appear in court, we are able to issue a summons. We choose not to. Where the summons then is given to the sheriff's department. They then try to find the person, give them another court date, and if they show up, they explain to the judge why they missed court, they don't get in trouble. They also let us do warrants. We just do failure to appear warrants. So if you don't show up to court, a warrant for arrest is issued. So if they don't show up, then they fail to appear in court. That means that they fail to appear in court, they didn't comply with the court rule, they get held indefinitely until trial, right? No, they do not. They do not get held indefinitely until trial. We'll skip over conditions because we're moving through. Sanctions. So, sanctions are violations of the conditional release order. That would be failure to appear in court. If they're told to get drug treatment, not getting drug treatment, it is also committing a new crime. We're going to focus on failure to appear. I failed to appear in court. Law enforcement arrests me. The state has to file a sanctions petition to have me sanctioned. If I did not commit a new crime, which failure to appear is not a new crime, the judge can do one of these nice three things right down here. He can admonish them either verbally or written, don't do that again. He can modify the conditions of pretrial release, or the maximum punishment is, or maximum sanction, because we can't call punishment, is 30 days in the county jail. So, I commit burglary, I fail to appear, I come to court the first time. We don't start with the maximum, you can't do the law. Judge sanctions him to 5 days. He gets out, doesn't show up. I sanction him to 10 days. Doesn't show up again. Judge sanctions him to 30 days. There is no way under this act, unless they commit a brand new crime, to detain them for failure to appear in the long term. In fact, this summer, I did a jury trial with an empty chair because our judge is trying to find ways around that. They admonished the individual if they didn't show up for that jury trial, we would do a jury trial because they have the right. I can't do that right without them there. So I sat in the courtroom, I did a jury, and I did a jury trial with nobody else in the courtroom. He was convicted, thank God. And there's an active arrest warrant for him right now. We are trying to go through solutions on this, but the burden on the court system is going to be insane if we have to go down this path. So then the final point there is revocation and pretrial release. We can either sanction for a new crime or revoke them for a new crime. And we'll get to that. That is one of the great things about the pretrial fairness sentence. So let's go into the old system. I commit class 3 meth possession. Judge sets bond at $10,000. I bond out for $1,000 because that's the rule. I commit a new meth possession a month later. Judge sets bond at $50,000. I post $5,000 cash. I get out. I then commit the meth possession again. Judge sets bond at $100,000. I post $10,000. I get out. That is not going to happen under the current scenario. So, under this scenario, you get pretrial release conditions for class 3 meth possession. while you're out on the class 3 meth possession, you commit another possession of methamphetamine. I can file a petition to revoke pretrial release. I have to show, with clear and convincing evidence, looking at here, that no conditions would reasonably assure the defendant's appearance for a related period or prevent the defendant from being charged with subsequent felony misdemeanor. We're really focused on that. My second meth possession, if all he said is drug testing on the first meth possession, there are things that can be done. You can order me to do an evaluation. You can order me to stay away from certain people. There are conditions to be done. Most likely, you'll be sanctioned on your second meth possession and not revoked because there are conditions. Your third one, though, he's now tried the initial conditions. He sanctioned you. On the third meth possession, we can revoke. What we're seeing now, though, is this is more prevalent in your burglary cases. A burglar gets charged with stealing from someone's shed. They wind up in jail. They burgle again. The judge detains them. That is more common. Under this old version of that, it would have been probably a $50,000 bond, followed by a $100,000 bond. They could have bonded out. An individual who's doing something near 25 years in prison, Mr. Devin Kruger, on one Saturday posted $20-something thousand in bond amongst various counties and was kept bonding out of jail. Under the Safety Act, that would not be something that would have happened over that time. Also, on the detainable offenses, I want to get to this. If we detain somebody under a detainable offense, they can't get out until trial. So what we saw under the old, because I'm going to try to be a little more balanced on it. Under the old system, I'll give you, this actually is a real example, but I'm not going to use the names because it's still going on. Individual was caught with child, allegedly caught with child pornography. Judge set bond at $500,000. On Saturday, that guy walked in $50,000 in cash and bond him out of jail. That was under the old system. Under the current system, he wouldn't have gotten out. He would still be incarcerated. So there is some good to this. It's just there's so much bad that the good gets buried under all of the bad. Again, each party has the right to appeal, and we have to have those hearings over and over again at these revocations. That's the decision points for that. Almost through. I'm trying to speed through this. Mandatory supervised release is parole. Under parole, it used to be a year. Safety Act makes it 6 months. And then after 45 days, if they have no violations, first review board can end their parole in 45 days. And that applies to all individuals, no matter when they were sentenced, that are released after 1/1 of 2023. This is one I think is insane. So a person released on electronic monitoring cuts his ankle monitor off, tries to evade prosecution, is guilty of class 3 felony. The person charged with misdemeanor is guilty of a class B misdemeanor. The most common type of use of electronic monitoring would be a person that is a domestic violence individual. So we know they're not going around and we can't detain them. If that is a class A misdemeanor to start off with, if they cut off their ankle monitor, it's a class B violation. And I told you earlier in the slides that we can't revoke your pretrial release for a class B misdemeanor. So if they're a domestic batterer that cuts off their ankle monitor, we can sanction them. The judge will probably give them the full 30 days, but they're getting out in 30 days. Then the financial side of the Safety Act. Person is held for 100 days in the Revocation County Jail, pleads guilty, judge sentences them to 100 days credit and 2 years probation. Just this random scenario. If they have a public defender, they cannot be assessed any assessments, so fees. That is all waived. And for every day they serve in the Revocation County Jail, they get $30 off their fine. So if the judge does not impose at least a $3,000 fine for that individual, they have no monetary damage from their incarceration and punishment. I've sped through so much of this because I didn't want a speech action. I wanted to answer questions and hopefully the chair will allow some questions to go forward.
Thank you, Mr. Garrison. Yes, we will have some opportunity right now. Mr. Mayor, did you want to speak prior to?
Let's see what they get done.
Okay. So we will again keep it brief. Yeah, you will come to the mic. I will come on out and choose people to come on up. Come on up to the microphone. I'll stay somewhere where you can address me though. Don't worry about it. Yes, sir. Oh, fine. Big fella who don't have the mic on, so. Yes, sir.
Mr. Garrison, what initiatives or legal actions are currently being taken by your office to address the distribution of fentanyl and other hard drugs in our community? So,
Here, I'm going to have Garrison.
what actions my office is taking to address the sort of fentanyl issue, fentanyl epidemic, and the distribution of fentanyl? Is that correct? That's correct. So there are two facets to that. We have the South Central Drug Task Force, which is the only division of District 18 that was not taken away from us this last year. They investigate all of our individual dealers. So we are going through that at a dealing level using South Central and controlled buys and things like that to address that issue. The biggest problem we have with addressing the fentanyl epidemic, and this is a very nuanced approach, and it makes it difficult for me to respond to this, but I'm going to try to be nuanced. If I use fentanyl with another individual and I were to overdose on fentanyl, and they call 911, everybody in that room is immune to prosecution for possession of fentanyl. Everybody. So when you see the Cook County numbers when we're talking about fentanyl cases, the most common interaction we're seeing for these type of fentanyl cases are overdoses. But when law enforcement is coming in and treating them under the Overdose Immunity Act, they can refer it to me. So our fentanyl numbers, at least for prosecution, have plummeted like crazy based off of qualified immunities that have happened. That being said, we are still using the South Central Drug Task Force to, I'm not going to go into the details of the devices we're using, but to monitor fentanyl and drugs coming in Cook County to try to address that issue. I hope that kind of answers what you're saying.
That's actually great. I can ask just one more question, and I'll step back to somebody else here. How do you coordinate local law enforcement to ensure that the drug dealers are being prosecuted according to law as far as coaching and scattering and everything of that nature?
So I don't put on trainings for law enforcement outside of certain things for my prosecution. That's done through law enforcement training standards board and those type of things. I would let you know that with there are, I believe, 14 active police departments in Cleveland County at the time. I am almost in constant communication with their agencies on all cases, including that. This weekend I did less than 5 calls. I did 3 or 4 calls to the county. Although I don't actively investigate, I do at any time I question. I'm open for communication to talk to them about how to go through that path. That being said, it's going to be more towards ideas and training standards for those type of issues. I mean, I'm a prosecutor and I know what things need to be gathered, but I understand the basic investigations that need to be done.
All right, thank you. Back in the back, come on up. He's got the hand up for you.
Hello. Okay. My car got stolen on Thanksgiving last year. I spoke with you a couple weeks ago. Since my car got stolen, I have reached out to the state police, Madison County, the courthouse, you, and I still have never got restitution. No papers filed on that. I'm getting papers in the mail saying that for the pole that this guy hit, I'm getting charged $3,300. And sorry, I'm nervous. I don't do this. And then I just recently got a paper saying that if I don't pay $3,600, that my driver's license will be suspended. I was supposed to hear something back from you 2 weeks ago, and I still haven't heard nothing.
So, I have permission to talk with you about this case, correct?
Yeah.
Okay. So the car was stolen out of Staunton and taken into Madison County. Madison County was the individual who was in charge. That's correct?
Yes.
I spoke with you in my office, called Secretary of State. We left voicemails for the Secretary of State, and then we left voicemails for Madison County State's Attorney's Office, correct?
No.
Well,
I don't know what you got.
So you sat with me was made phone.
Yes.
Okay. So then Madison County State's Attorney's Office called me back the next day and assured me that their victims' compensation people would be reaching out to you. If they've not reached out to you,
I mean, they haven't reached out to me since Thanksgiving. What's good? I mean, and now it's been 2 weeks, and I'm doing the legwork. I'm trying, but this is kind of what our community is going through. These guys are doing stuff. He got picked up off the interstate. A state cop dropped him off at the hospital. He refused treatment from the hospital. Staunton cop showed up, ran him off. He came across the street, stole my car. The cops seen him steal my car, and here we are. I'm gonna have to do the legwork, which most of our communities has to because these guys are trash.
I'm going to step in here just for a second. First of all, you're not alone. There are a lot of people in here who have had their property stolen, things taken. They've had to see Narcan administered in their front lawn. They have to have Narcan in their homes in case their kids pick things up. The legal process isn't moving fast enough in their eyes and their minds and maybe in reality. But we have to keep our confidence tonight on how we go forward. So keep it in hypotheticals. If something happens, what do I need to do to make sure that the chief and his officers have everything they need to give to this gentleman so we can put these people where they deserve and need to be. So that's
So I understand it's common now. So as to your case, the enforcement part is that was charged in Madison County. I don't control Madison County.
You are the one that's actually took time to talk to me.
Yes.
But Madison County is also telling me that the paperwork was filed wrong from the state police. I think that's from each county.
And so I talked to the state police about that as well, and I reviewed the paperwork. What it appears to get to your specific scenario is the Secretary of State is making an error. So I reached out and talked to the witness coordinator in Madison County, the attorneys there. They assured me they addressed that issue, but call me tomorrow, and I will personally address the issue again. Okay?
Right. And I have one more thing. If someone under the influence of methamphetamines comes into my home where my kids witness it and chase him down, we identify him, we find the guy, the cop went to talk to him, he said, clearly he's high, but there's nothing we can do about it. How is there nothing they can do about it when he came into my home?
So I know the specific scenario. We'll talk about that scenario in general, okay? So being under the influence of methamphetamine, fentanyl, or any narcotic under the state laws of the state of Illinois is not legal. The only time it's illegal is if it impedes traffic. So when you have something like that, that would be a criminal trespass to residence of the person present. They can be charged with that offense, and they cannot be detained. So you wouldn't prosecute in that case. They would not be detained eligible under the statute.
Can I follow up on that question? One of the big questions, and I know I'm talking to the chief, one of the challenges has been what needs to be done by the homeowner? What is the process for those people in there to make sure the charges are filed?
So if we're going to focus on charges being filed, doing another process, you talk to law enforcement. Law enforcement would either cite them based on this procedure, or they'd be taken to jail. They would most likely have to be released under that act that I just talked about, but they would be charged and then prosecuted. If someone broke into my house, I would have to find law.
Ladies and gentlemen, now one person up here was on the state legislature when that got passed. We are trying to deal with what we can through the lens of the Illinois law that we've been dealt. We all have a new deck of cards. We cannot play the old deck of cards anymore. So we're trying, I understand, but I'm just trying to use this time so we can talk about what can actually be done. Sir, come on up.
I want to thank our police, our government, our officials. They do everything that they are allowed to do. This bill was passed out of Chicago. It was passed in the northern area. Around 36 Democrats voted for this bill. Republicans had to try to reverse it, and they were knocked down. We have had to live under the empowerment of the North. should somehow be able to change this. This is given the right, and I have the act in Article number 2. It says no representation without population. They are counting the what is it, the incarcerated people. They are doing a census of the incarcerated people every year to get the numbers to give to the electorate, the Board of Elections. So they will start dealing with extra numbers for our legislatures to use in different districts. But this bill is handcuffing our police. It is handcuffing them from doing their job. It's not their fault. We have to work with them. We have to have video cameras, and we have to prove to them, and they will do what they can do. I guarantee it. They'll put our chief, they'll put our prosecuting attorneys, and they do their job.
All right. Next.
Hey, Dave, you got Tuesday.
Okay. Some people didn't get a chance to come in. They're in the back, so go ahead.
Good afternoon, my name is Natalie, and I'm a solution-based individual. What are the solutions that you guys come up with to solve some of these issues of mental health, substance abuse, and housing that we have here in Staunton? Like, these are all contributing way before this law passed, and now they are snowballing very quickly in our community. And what solutions have you thought about? Have you thought about possibly saying about any grants that can be available to solve some of these issues? Looking into maybe some of the empty buildings we have in our community that we could possibly put some community-based things in to help support these individuals. Like, what things have you thought about to not only support these individuals, but support the rest of our community?
All right. Thank you. I'm going to pass that one on over here to the mayor to answer on that.
On your question there is stuff going on. There is, I don't know if any of you heard of Safe Passage. It is Montgomery and Macomb County. It's in Litchfield. Anyone that wants help, we will steer them up there. And they've got all the resources, and that's where a lot of that is. I asked them. Well, Staunton has no money for housing. Okay.
All right. Yeah. Hold on. I understand. This is very personal to a lot of people, and everybody. Some of you went to school with some of these people we're talking about. We're talking about people that have chemical issues. In other words, they need medication, they're not getting it, and they end up in a homeless camp. There are others that are ending up with issues with drug abuse, drug usage, and addiction. We have a lot of different areas and issues. I believe we had other initiatives that you wanted to mention as well.
The next church does NAA. They do, and I actually ran to one of their. I would say Page. He went to jail, and I really didn't get into what he went for, but I can tell you he's got a job and does a lot. He's done a lot of good now. Back to small towns do not have that kind of thing. One grant is not going to solve the problem on that. Back to Montgomery and Cook County, they do get steady money for that, and that's when we send them for stuff that people want help. A lot of these people, I call it two kinds of homeless here we have. We have a meth problem, and we have had homeless. I don't know the lady's name, but she got her up in
No.
what?
Doesn't matter.
First Bill for some help. She was homeless here for a while. We have another guy. Most of this is a meth homeless problem. There's no doubt about it. And we talk to them. Some of them will tell you they don't want them. They're happy living like they are. But what I will say is, we're not going to. We will fight everything we can as far as them on people's property, but people can't go to Facebook and put this stuff out. You can, but you got to report it to police. You know how many times we look at Facebook and we'll talk. You'll go, did you report it? No, they haven't. But again, uh, so that's a lot of that. But there is help for people. We will help people if they come to us. If you know someone we need to talk to, we will.
All right, we have, this is really not a line, but I will take the line for right now. So just stay where you're seated. It gets a little bit messy. Don't want to really tie up everybody over here. But sir, if you want to speak.
Hey, my name's Jim Wilbrecht, and I'm in St. Louis, but I come out here to represent over 1 million people dead from fentanyl right now. I come out here and I set up a little stand on the police yard a couple months ago, and I had a woman stop and crying to me, saying how glad somebody's here doing something because nobody in this town talks about it. She lost her child, and she had never told us about it because of stigma. I had another woman stop. She works in the medical profession, and she said it's amazing how little you hear about this in this town, what's going on. You have people dying left and right. My son, Austin Wilfred, was 23 years old. He died in Bridgeton, Missouri. He was given a marijuana cigarette, and it was laced with fentanyl. Bridgeton Police Department says we do not investigate those, sir. I'm sorry. Well, I investigated, and the kid's in jail now. The DEA thinks Lonnie Ziegler, same thing. He shouldn't be dead. I met Lori a little while back, and I keep telling her we keep fighting for it. People, we need to come together. This drug is killing everybody. There's a drug-induced homicide law in effect in Illinois, and it has been since 2018. Now, that law states that anyone gives anyone else a drug and that person dies, it's a homicide investigation that should be started. I don't know how you do that here. Because if anybody dies from a drug, that means somebody gave it to them. I have Chicago Police Department protocol where they go out on every single call of a drug overdose call, and they start a murder investigation.
Sir, another 15 seconds here.
Well, Missouri is just has the same drug use homicide law as August 28th is in effect. And I've got a meeting with Chief Commissioner Tracy, Chief of Police, City of St. Louis, and he's willing to look at this and put this into effect for the city of St. Louis. Now, I don't know any of you here. I know Lori, but I bet there's some of you in here that's lost somebody, or you know somebody that has, and it should be shame, shame, shame. It should be let's take out what's going on.
Hi, everybody. I have a big house, so I probably don't need this. I live on South Howman and West Spring. Chief knows where I live. Friday, we had a situation. The apartments was selling drugs. My husband called the cops and let them know the apartments were selling drugs. I was taking my son to football. Nobody came. Not one cop came. I came home. My husband let me know what was going on. The other side of the apartment, when I came back, it looked like a convenience store. He just switched sides where we couldn't see it. Our cameras couldn't see it. An hour later, he came back to my side where I could see it. I called dispatch, let dispatch know what was going on. 3 cops came when I called and raised hell. They said, "What's going on? We didn't know what was going on." I said, "My husband called an hour ago. Not one cop showed up." I said, "We call maybe 3 times a week." He says, "We're going to have to let Chief know because we don't know what's going on." It's ridiculous. Either our chief's not getting the message that we're calling or nothing's being done. Not one cop when my husband called. Somebody could have caught him in the act. We had to get license plates numbers. When the cop came, mind you, 3 cops license plate number, cameras of the guy doing it, mind you. Mind you, they stood there and talked to me.
You're addressing me, not
Sorry.
Thank you.
3 cops stood there chit-chatting with me and said, looking for the guy. License plate number, make the car. Nothing was done. They could have caught the guy. The guy left with him. Nothing was done. So don't tell me cops are doing us a favor. Don't tell me.
Thank you.
I live over on East North Street, and we had a problem with a drug house across from my house for probably a year. Recently burned down. I'm sure everybody in town heard about that house catching on fire because it was caught on fire by somebody that was staying in the house and was doing drugs. They got angry and decided they were going to catch the house on fire. We were in constant communication with the police at least once a week about things that were going on over there, and we were always told by your officers, Chief Door, that there is nothing that they can do about anything that's going on over in that house. We had concerns about people coming on our property. I had one of your officers tell me in my driveway that he can do nothing about anybody trespassing. And that's when I called and I spoke with Macomb County State's Attorney. He told me that's not factual, so I think your officers are giving people incorrect information in town.
So I guess
Everything is going through the chair. All right. You can blame me, but we have 10 minutes left. All right. We don't have a lot of time, so we're not allowed to. We cannot discuss any specific case. Period.
so. I
Go
have
ahead.
a question
Yes,
more
ma'am.
directed at the police chief. So what is the answer? Just because they're not detainable offenses does not mean that they can't be prosecuted. And in the end, they can go to jail. Just because you can arrest them, hold them for 24 hours, and then they can be prosecuted. So I don't understand. My personal experiences, I've sent video and pictures, and no one's ever done anything. They actually told me to board the house up so people couldn't keep getting in. I moved my mother closer to me. She's 81, and now the house is for sale and vacant, and they just keep kicking in the back door. I've sent video. Nobody does anything. So I work in the Madison County court system, and we routinely wrap up. So are you going to start arresting people? Do you want to show up? What do you plan to do to fix it?
Thank you. You want to address how many? Yes, absolutely.
So I
hotspot.
yeah, so I don't know that specific scenario. I don't know many of these specific scenarios on top of that. I apologize for that. But I will tell you there are multiple cases in jail right now, which are multiple trespassing properties, where Staunton has put together a case where they did the Class A misdemeanor, and the violation was sought. In fact, facing sentencing hearing on one of the individuals looking up to 6 years in prison on those type of things. Now, 2 or 3 is a drop in the bucket from what I'm hearing here. But we're still working through the mechanisms. So I don't know the specific cases, and if someone wants to call my office and I'll talk to you about where we're at certain cases you're victims of. But we are working through we call accumulation of charges to try to address that issue. So we do track to get to that revocation point. So unfortunately, your first or second time being a victim of a crime under the Safety Act, as we just explained, may not allow for someone to be incarcerated in the long term. But we are working through with this agency and other agencies to get accumulation of charges to file that petition to revoke pretrial release, and it has been successful in certain scenarios. The issue we're having is that we are very new to this law. This law is less than a year old at this point in time being implemented. And we're working through with all the stakeholders to try to create a system that lets us move quicker with this. But as still, it's going to be limited resources with officers and limited resources with my office to keep moving this forward as fast as possible under commission charges.
But they have to show up and arrest these people and actually press charges. In my instance, it's been at least 3 times, and nobody has even been arrested or pressed any charges. Like you can't, like more cases, the more likelihood of a prison sentence in the end, even on a class 3 felony, burglary or theft over.
So
Not arrested, you have to be charged.
I would agree. So I'll give my office a call tomorrow and I'll talk to you about that situation. Okay?
All right, sir, you're not looking at on the floor, sir. Go ahead.
I have a few questions about castle
Yeah.
doctrine. What's the implication of the castle doctrine? Do I have to do to retreat from my car or my house? Or can I just force to conduct my house and my kids and my wife? Or are you going to arrest me if I use force to stop them?
Under Illinois law, the standard is appropriate reciprocal force.
Okay.
So if someone's standing on your property, you can't take out a firearm and shoot them.
I understand that.
That's that. So you can use appropriate reciprocal.
Do I need to steal weapons if they come into my house? Or
If they break in your house and break down your door,
Yeah.
and looking at charging, I can't get into specific hypotheticals, but I highly doubt if someone's breaking down your door while you're barricaded inside without seeing prosecution.
okay, I'm just curious. In some states, you have to do to retreat.
Yeah, I highly doubt. Yes. So
Do I have to do to retreat from my house?
they do not have any leadership.
Okay.
Thank you.
My name is Ron. Next, my question is, I'd like to see a list of who voted for this bill.
I can put a few minutes on the
The second question is, you mentioned that Cooper County, I think you said, is about 20 points higher in their retention rate than the state average. Is that because we have better judges, or what is it?
I can't speak to that. I don't know. That's the data is just not coming out that I can read the website for, and you can try to analyze that. But I have to take time to process why counties are losing the cases. It could be because of better judges. Yes, that is possible.
How would the list of the elected officials that voted for this bill, how would that be made available to us?
I can pull it up right now and see if I can get that.
How would I copy it?
There are two versions of this bill. There's Safety Act 1 and Safety Act 2. Do you want to just go over those?
Yes.
Okay.
Chief, this question goes to you, sir.
You can come to me. It can be in regards to. All right. That's Robert's rules.
What are we doing, since it seems our hands are tied legislatively? What are we doing as a police force to help stem any crime that's been getting worse? You know where I live. We're starting tagging, property destruction, those things. Are we looking into stepping up police presence, hiring more officers, more patrols? Any questions on that?
Well, actually, I'm going to deviate from Chief on that one and talk, since when it comes to hiring new officers, when it comes to policing the police, that would be the mayor. So,
Yeah, about hiring new officers. I call it, since demoralizing the police probably 7, 8 years ago. 7, 8 years ago, it's been really tough for our communities to hold on to the police because the state cops would they make it real easy for someone to cross over, and that's what we've been seeing. So and we used to have part timers filled in a lot, which doesn't happen. So the last few years we have hired, but then they'll leave, go to better paying jobs or wherever, and we're stuck back rehiring. For the first time ever, a few years ago, or maybe this year, we actually started having to pay policemen to go to their training. We used to not have to do that. We could sign a 3-year, and we had to leave then. we were operating on 4 officers for a while, and now we should have 8 back after 6 back, and then we'll have 8 more. But they can leave again. The 2 that did leave, uh, they're they're just paying that money off, and they're going to other places. So it's been a tough process, and that's what we used to see from smaller towns get stolen from for big. Till the market fills up, that's what you're going to see, on the police. I mean, there's times we used to have 2 or 3 officers on. Now we're just trying to fill shifts to make sure we have someone on. And hopefully, these new guys that we hire will stick around.
Do you feel it's an issue being so close to a metropolitan area and just outside of Madison County? Is that part of the issue?
I went to some meetings with the Madison County sheriffs and them before, and that's what a lot of them have went to. Mainly, I would say higher paid jobs, which you can't blame somebody. I mean, that they're going to state police, they're going to Baltimore or wherever for a higher paid job. That's what's been happening. So then we're back to rehiring again, which takes a process, how that works out. A lot of people don't understand that, and I'll talk a little bit about the police. Once you go over 5,000 people, which before I even got in there, it's probably in the early 2000s or 2000. Once you go over 5,000, and a lot of aldermen that get on don't realize this either. The city council has no control really of hiring police. That goes through a board that we put together, and they hire the police, and they also discipline them too. So that's a process. But yeah, for the last several years, we're losing officers, and then we got to rehire, which makes it tough. I think we lost several to the county, to wherever else.
You want to do your final remarks? We got 4 minutes.
Some other things I'm going to say, just these are minor things. I know that there's been a lot of bike stuff. We had a program. We'll bring it back up, bike registration, where they will engrave on the bike a number. So if there is a bike stolen out there, we can look and see these numbers. We'll be putting that on the internet, so you can look for that. And let me see what else we got. We've got a new program here. I can set these in the back when you leave, or I can leave them here and come up and get them. If you guys have cameras on your houses, you can register them with us. So when we do have something in that neighborhood, you don't have to give it to us, but we can ask you, hey, we had something in your neighborhood. We would like to see your cameras and see if we can help. Now we're just kind of running around looking who's got them on their houses. But if people want to register them with us, that would really help us get going on that side of it. So that's another thing. That's a couple things. Other than that,
No, and the camera initiative would be very very effective. In fact, I know Chief and I work quite regularly in my neighborhood, sharing videos and making sure that the correct charges get sent. Folks, everyone is frustrated, whether no matter where you stand, no matter what your political affiliation is. We now know at least what the lens that we have to view these items, what our officers can and can't do, and how it's going to be handled on the court side. As far as the council, we have to be over for our council meeting at 7 o'clock, so we have a hard stop at this point in time. So I'll take a motion for adjournment.
so